5 seconds to go. Start. Registration of rent agreement cannot be interpreted to have the effect upon it as are prescribed under section 49 of the Registration Act. Moreover, the prohibition created by section 49 of the Registration Act is invited only qua the documents which are required to be compulsorily registered under section 17 of the Registration Act or under the provisions of the Transfer of Property Act. As observed above, the registrability of a rent agreement under the Punjab Rent Act is referable to section 4(2) of the Punjab Rent Act and not to section 17 of the Registration Act or any provision of the Transfer of Property Act. Rather, subsection 1 of section 4 of the Rent Act uses non-obstant clause even against the Transfer of Property Act in the matter of requirement or execution of the rent agreement. Therefore, merely because a rent agreement is not registered one, that would not operate as a bar for leading the same in evidence. Section 4 of the Act is a complete code in itself on the point of execution and registration of the agreement. This being a subsequent and specific act shall be deemed to have superseded the provisions of the Registration Act on the matters dealt with by it other than specifically protected by the language of this very Act. This is particularly so because of the language introduced in this Act by the legislature, which has been used in the nature of overriding the provisions of the Registration Act and Transfer of Property Act. Accordingly, this court finds that the appellate authority has rightly arrived at the conclusion that non-registration of the agreement would per se neither make the agreement as void and liable to be not considered by the courts, nor would the same make it inadmissible in evidence. The registration, if resorted to by the parties, would have the presumption of truth attached to the document. However, even in absence of such registration, either of the parties can rely upon the same if it is admitted by the other side or is proved by one side in accordance with law. So far as the present case is concerned, a bare perusal of the pleadings of the parties show that the respondent landlord has mentioned in specific details the terms and conditions of the agreement entered into between the parties. The petitioner, in the written statement filed before the rent authority, has not denied any one of the details mentioned in the petition filed by the landlord. Rather, he has resorted to only a vague denial by saying wrong and denied. Provisions of Order 8, Rules 3 and 4 CPC requires the pleadings of the parties to be specific so as to decipher the dispute between the parties. If the defendant in a proceeding does not specifically denies the categoric and specific pleadings of the plaintiff, then the court would be well within its scope